So welcome to Understanding the Basics of Agricultural Conservation Easements. My name is Audrey Thompson, and I'm a staff attorney here with the Penn State Center for Agricultural and Shale Law. The center provides legal and academic research through its website to legal stakeholders in rural communities, and we provide much of our content through our website at aglaw.psu.edu. On our homepage, you can see that we publish our agricultural law and shale law weekly reviews, which cover recent ag and energy legal developments and include a full listing of relevant state and national legislation and executive branch publication. We also host several resource compilations. We have our agricultural law and shale law virtual resource rooms, which provide a compilation of various resources, including statutes, regulation, case law, and related articles on a single topic in agricultural energy law. We also have our issue trackers, which are similar to the virtual resource rooms, but they present a single issue in a timeline format. So you can see that issue developing through statutes, regulation, and case law through time. We also provide audio and video content with our agricultural law and podcast and Farmland Energy Legal podcast. These are available on all of the major podcast platforms and our YouTube channel where we'll post a recording of this webinar when it's finished. On our events page, I just want to let you know here, this is where the resources are published for this webinar here. You can find the PowerPoint, and we've prepared a resource sheet here that includes multiple websites that have to do with agricultural conservation easements. So don't miss out on all this great content. Subscribe, and you'll get all of it in your mailbox every week with our newsletters and all of our emails. One last plug for the center here. I do want to let you know about our mediation program. We operate the Pennsylvania Agricultural Mediation Program, which is funded through USDA. This program has historically facilitated mediations between ag producers and USDA, but its authorization has been expanded over the last several years, and we are now able to mediate a broader range of issues between different parties. So please feel free to contact Jackie Schweickler. They're listed, our program coordinator, with any questions about ag mediation. Today's webinar on agricultural conservation easements is part of the Center's Understanding Agricultural Law series, a course designed to provide subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent agricultural or rural clients, but who may not necessarily specialize in agricultural law. This series is wholly sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center, which was established through the 2019 Pennsylvania Farm Bill. The Agricultural Business Development Center aims to enhance the long-term vitality of Pennsylvania farms by supporting farm transitions, both from generation to generation and from conventional to organic, supporting beginning farmers, providing risk management education, and providing financial assistance through low-interest loans and grants. This is the 12th webinar in the Understanding Agricultural Law series. As you can see, we've covered numerous topics so far, including ag labor, land use regulation, crop insurance, conservation programs, ag finance, and Pennsylvania's Clean and Green program, and many others. Recordings and materials for all of these webinars are available on our YouTube site, and accompanying materials can be found on our Understanding Agricultural Law landing page. Upcoming topics in our Understanding the Basics of Ag Law series include Understanding the Basics of Landowner Immunity Statutes on May 19th and the Farm Credit System on June 23rd. Free CLE credit will be provided for all of those webinars, and registration is currently available for the May webinar, so we encourage you to go ahead and sign up as soon as you can. I will now turn this webinar over to Ross Pifer. Ross serves as the director for the Center for Agricultural and Shale Law and is the clinical professor of law at Penn State Law, where he teaches property and oil and gas and agricultural law. He also runs the Rural Economic Development Clinic. Ross, the screen is yours.
Okay, thank you. Thank you, Audrey. Just getting my my screen positioned here. So thank you all for joining us this afternoon. Okay, so thanks again, Audrey. And so today we're going to talk about ag conservation easement programs, and sometimes these programs are referred to as PACE programs. PACE standing for Purchase of Ag Conservation Easement Programs. And just a bit of an overview as to kind of how I'm going to work through the content today. We'll start just by talking kind of a big picture about ag conservation easement programs, kind of the what, the how, just kind of the background of these programs. Then we'll go through a little bit of the history. Then we'll talk about some federal programs, and then talk about state programs generally, with obviously a little more detail on Pennsylvania programs, and then discuss some of the issues, both legal and policy, that are kind of facing these programs, or that will be addressed in future years. Okay, so the big picture. So the what, where, and the why. What are purchase of ag conservation easement programs? And I'm just getting ready for the property class, that exam that I teach at law school. Just finished a review session right before this webinar, and so we talk a decent amount about easements in that class. That's what purchase of ag conservation easement is an easement that is being imposed on the land. Now, with easements, generally an easement is a right to use a particular piece of property, or for a particular purpose. Normally, easements are affirmative, meaning you have a right to go on to someone else's property to make use of it. But in these PACE programs, with an ag conservation easement, it's a negative easement. It's that you are prohibited from doing something on your property, and you are voluntarily, the landowner is voluntarily agreeing to impose this prohibition on a particular use of the property. So it's a purchase of an ag conservation easement, and it's either being purchased by the government or a government entity, or it's a conservation easement that's being funded by the government. So the farmland owner is essentially selling the development rights to state or local government. So we're separating those rights. So you think of the bundle of sticks that a property owner has, and all of the different rights that go along with property ownership. And when there is a conservation easement, an ag conservation easement that's imposed on the land, that property owner is basically voluntarily agreeing to give up one of those sticks, the stick to develop that property. So these conservation easements normally are putting a restriction on the property that limits its use to agricultural uses, or it prohibits certain uses of that property in the future. So what we're not going to talk about today, I mean, we're just going to talk about these purchase of ag conservation easement programs. So we're not going to talk about conservation easements that are for which the property owner who creates the easement is getting income tax benefits. So where the property owner donates a conservation easement or sells a conservation easement in exchange for income tax benefits. I mean, that is a common way that conservation easements are imposed on the land, and we're not going to talk about that today. We're not going to talk about conservation easements that may be imposed on the land for some other purpose. And we're not going to talk about conservation programs like CREP or EQIP generally. Now, in one of these prior Understanding Agricultural Law webinars, we did have a program on conservation programs. So I would encourage you to review that if you're interested in learning more about that topic. Okay, so where are these conservation easement programs? And they are at the federal, at the state, and at the local government levels. So there are different programs at each of these levels. Some states have different programs. Local government often is working with the state government in granting these, or in providing funding for these conservation easement programs. Okay, so this graphic kind of gives an illustration of what states have these programs. And you can see that, I mean, this graphic is showing the states that have state programs, that have just local programs, and then the states that have both a state and local. So the dark green indicates those states that have both a state and a local program. And you'll see, I mean, maps like this are always interesting, just to kind of see the differences and the trends across the country. And you can see that these purchase of ag conservation easement programs are, you know, every state in the Northeast and along the Mid-Atlantic has a program. But as you get out into the Midwest and the Great Plains, a lot of those states that are, you know, large agricultural states do not have these programs. You'll see a total of 28 states have active programs, and every, you know, Pennsylvania, along with all of Pennsylvania's neighbors, have a purchase of ag conservation easement program. Okay, so what's the purpose of these programs? And I guess just that the kind of the bottom line is that the policymakers, at the state or the local level, are trying to prevent, or the national level, they're trying to prevent the loss of agricultural land. And so, you know, a number of reasons why we want to prevent the loss of agricultural land, from just an open space standpoint, preserving the landscape, the heritage of agricultural development, economic development, that often agriculture is you know, it can be an economic engine, that we want to protect that, and we want to prevent agricultural land from being lost, promoting local food system as well. So I mean, a lot of different reasons as to why policymakers want to prevent the loss of agricultural land. So as we look at the history of these purchase of ag conservation easement programs, you go back to the 1970s, at a time when there was starting to be a recognition of the potential issues that were being created by or through the loss of agricultural land. And so there was a national agricultural lands study that was initiated by USDA and the President's Council on Environmental Quality in 1979. And the charges to that committee was to look at how much agricultural land was being lost or converted to non-agricultural uses, looking at the consequences of that, and then making any recommendations to try to minimize excuse me, to minimize the ongoing loss of land or the adverse impacts from the loss of the land. And the conclusion, I mean, these conclusions, you know, as you look at them today, I mean, they're certainly not really earth-shattering conclusions, but they you know, did kind of document this, you know, this land loss, and concluded that, you know, a lot of this land loss was as a result of small, you know, piece by piece loss of land, and in an incremental fashion, and kind of noting that this really had not been an issue that was addressed at the national level, and the fact that the uncertainty that could be created by this piece by piece loss of agricultural land could impact the willingness of farmers to or others to invest in this agricultural land. And so excuse me. So the demand for products, you know, we were seeing kind of a loss of land, but we were also seeing an increased demand. So we were seeing a need for more agricultural production and having less land upon which to have that agricultural production for, you know, international trade, increased population. You know, ethanol production is kind of an interesting an interesting factor here, and kind of shows how trends can really be cyclical, because, you know, at that time in the late 70s and early 80s, there was a, you know, great concern about importing fuel from international sources, and there was interest in ethanol, and then of course that kind of waned, and then, you know, a few decades later it kind of picked up again. But this study was pointing to, we need more land, but yet, or we need more production of agricultural commodities, but we're losing land upon which to have that production. So the recommendations, they recognize that at a national level, we needed to start looking at these issues, and we needed to start, you know, the federal government needed to support the state and local governments, recognizing that state and local government really had the primary role, but the federal government needed to support those efforts. But the federal government also needed to, you know, in areas in which it was operating or in which it had programs, it needed to focus its efforts to make sure that it was, you know, that it was not doing things that were going to contribute to the loss of agricultural land. And so within that context, excuse me, within that context, the purchase of ag conservation easement programs began. And now that the National Ag Land Study was in that late 70s, early 80s timeframe. And you see from this slide that these purchase of ag conservation easements really started prior to that. The very first one was a local program in Long Island, that was started in 1974. The first state program, you had Maryland and Massachusetts in 1977. Connecticut and New Hampshire followed shortly thereafter. So these state programs are starting. The National Agricultural Lands Study is released, which really kind of increased the trend of states enacting these programs. And I think when you look at these purchase of ag conservation easement programs, you have to put them in the context of this is one tool that can be used, but there are a lot of other tools that can be used to assist in farmland preservation. You know, ag districts, where you have particular areas that are determined to be suitable for agriculture, where landowners receive certain protections. Preferential tax assessment, where you have, you know, Pennsylvania's Clean and Green program, where farmland or other eligible land gets assessed at a lower rate. Right to farm laws, where you have farms that are receiving certain protection from nuisance lawsuits, as well as some other protections. Just general zoning or other kind of real estate programs. And then the technical assistance programs, where we're giving farmers assistance in a number of ways to try to make their farms more viable. So these are a number of the tools. Purchase of ag conservation easement programs being one of those tools, which are really focused on, we want to keep farmers in business. We want to preserve this agricultural land. We want to reduce the pressures upon agricultural land from, you know, encroaching development, the nuisance lawsuits, the higher taxes, but overall try to minimize or eliminate the incentives for farmers to exit agricultural production and to convert the land to non-agricultural uses. And I think purchase of ag conservation easements are perhaps the most direct way of doing that, because you're putting a legal tool in place that prevents that development. And we'll kind of, towards the end of the program, kind of contrast that with some of these other programs. Okay, so how do these purchase of ag conservation easement programs work? They, you know, you have the farmer who is essentially imposing an easement upon the property that prevents the development of that property. So, you know, it certainly removes the incentive to to convert farmland to other uses because it's providing revenue for the owner of the land. It's providing revenue to them so that they can continue to farm as they have been and as they intend to do in the future. They can still sell or transfer the real estate to a family member or a non-family member, but that easement is going to run with the land and is going to impose obligations on a subsequent owner. So a lot of farmers say, well, I want this land to always remain in farming, and through these purchase of ag conservation easement programs, legally that's required to do. So any subsequent owner is going to be bound by those the restrictions in that easement. And so we're essentially separating the development rights, that it can be used for agricultural use, but it can't be developed. And so we're imposing this easement, separate those rights, and this can be a pretty effective tool for new and beginning farmers as well, because in theory, it should make this land more affordable, because it can only be farmed. It can't be developed for residential or commercial purposes. Okay, so let's talk about some of the federal programs that are in place. Okay, when we go back to the 1996 Farm Bill, and the Farmland Protection Program was established. It was later referred to as the Farm and Ranch Lands Protection Program. And going back to that National Land Study, I mean, that recognized that this particular area largely had been was an area of state action or local action. This is not conservation easements, or the purchase of conservation easements is not an area that the federal government has a long history with, and you kind of see that they're coming a little bit later to the game in this area in establishing this program in the 1996 Farm Bill. In the 2014 Farm Bill, a lot of the existing programs, this Farmland and Ranch Land Protection Program, the Grassland Reserve Program that had been established, the Wetland Reserve Program, all of these various easement programs, purchase of easement programs that were administered by USDA were kind of consolidated into the Ag Conservation Easement Program. So now it was, rather than having a variety of easement programs, they were all consolidated under one umbrella. And the way that this program works is that USDA works with other entities. So USDA can work with, it could be a government entity, it could be an NGO, and USDA provides assistance to that partner entity to acquire and manage the easements. So they generally will provide up to 50% of the fair market value, sometimes more for certain lands, but they'll provide that value. And just as these conservation easements generally do, they limit the non-agricultural use, or the non-agricultural activities on that land. And and I guess it's important to to emphasize here that when we think of federal conservation programs, CREP is probably the one that immediately comes to mind, just because it's the oldest and certainly has been a very popular program. With CREP is not a conservation easement, and with CREP, the landowner is signing a contract that limits certain activities. But CREP, and just to highlight on this last bullet point that I have on the PowerPoint, the ACEP-ALE easement, it's an easement on working agricultural land. So, this is land that is being farmed. And when you think about CREP, again, CREP is not an easement program, but CREP is also not a program on working agricultural land. CREP is is a land retirement program. It's a program where you're taking land and saying, we're not going to farm on this land because it's environmentally sensitive land. So we're taking that land out of production. And I guess I'm just saying that to emphasize that, these easements, we are dealing with land that is and that will be farmed. This is a pretty key distinction from the goal or what's being done with CREP or other land retirement programs. Okay, so if a farmer wants to enroll in this program, they apply. NRCS has the ability to establish certain cutoff dates. The rankings, which the next couple slides are gonna deal with a little bit with the ranking criteria, but the state conservationist at NRCS has some discretion to to put local concerns or local considerations in how the applicants, the land that is being sought to be entered into this program, how the land is going to be ranked. And so, this next and the next two slides, obviously there's a lot of content here, and my intention was really just to give you a very big picture sense that there are specific factors that are looked at by USDA in determining whether to accept certain land into this program. And if you look just at the first couple lines of the ranking criteria, you'll see that I'm just going to read the language. At least 50% of the weight of the ranking factors must be on the national criteria, comprising 200 points out of 400 points. So there are 400 points. These applications are going to be scored out of 400, and at least 200 of those points are based on this national criteria. So same criteria everywhere in the country. But when you get to, here we're at the first part of the ranking criteria. When you look at the remaining weight, so the remaining points out of 400 is up to the state conservationist. So these programs, there is, they're all applications across the country are certain factors. The same factors are being applied across the country, but up to half can be based upon local factors. So the money's coming from the federal government, but there still is very much a heavy involvement or consideration given to each state. Okay, so these easements, they can be acquired through kind of the standard method where a landowner applies, and then the USDA or the entity, the partner entity that has the funds from USDA is purchasing that easement. So I think that's what we all think of as kind of the classic application of these programs. But there also is a buy, protect, sell, a BPS method where the as part of a transfer from a landowner to another landowner, the partner entity is kind of involved in that transfer. So the partner entity purchases it and then transfers the land subject to the easement. So at the front end of the transaction, it looks just like a purchase, but on the back end of that transaction, you have a sale with the reservation of an easement. So that can be used in certain situations where at the end of the day, you have land that is subject to, in either of these cases, you have land that is subject to the easement, but you kind of have different ways of getting to that end, excuse me, getting to that end point. Okay, so now I want to shift gears and talk about state programs, and I'm going to talk as we go through here. I'm going to talk just generally about state programs, some of the considerations that are in state programs. And then we'll talk a little bit more specifically about Pennsylvania. And the idea of these understanding agricultural law programs, at least kind of as we've moved forward through this first year, is to really provide kind of a high level overview of certain topics, with the intention that we will be drilling down and we will be getting into a little bit more depth on some of these topics. So, if you have a desire, if you'd like to see us drill down on some of these topics, please let us know, because we do want to respond to get the feedback and respond to what topics you all are interested in learning about. Okay, here, this is the same graphic that I showed earlier, showing that the Northeast and the Mid-Atlantic, every state, even those states that we don't always think of as big agricultural states, they still have purchase of ag conservation easements. There are programs outside of this region, but a lot of states that we do think of as agricultural states do not have this particular program. Now, when you look at how large are these programs, what's the amount of acreage that is that has been preserved, what's the amount of acreage that has easements installed on the land through these programs, you see that Pennsylvania is really a national leader in this. The states, the number of acreage that I have on the right, these aren't necessarily the top. I mean, these are the top states in the Northeast or the Mid-Atlantic. Actually, California in recent years has kind of seen a spike. So I think their total numbers, I think, are somewhere around the 200,000 acre. And Colorado, I think, has a much broader program. So they're on land that we wouldn't necessarily consider as agricultural land. So their numbers are pretty high as well. But you can see, I mean, a lot of acres in Pennsylvania, and then Maryland, much smaller state, but the amount of acreage that they have preserved is pretty close to that in Pennsylvania, and Maryland and Delaware, again, some small states that still have a lot of acreage that's preserved. And when you look at the total amount of acreage in the U.S. that is preserved, Pennsylvania and the states surrounding Pennsylvania certainly have a significant percentage of the total acreage in the U.S. that is enrolled in one of these programs. Okay, this graphic, and this is a little bit dated. I couldn't find a more recent graphic that expressed this information in the same way, but this is from 2017. So 6 years ago. It shows you on a county basis in Pennsylvania, the percentage of farmland that's enrolled in the ag easement program. And you'll see at the top, the statewide acreage is listed at 533,000, and that acreage is now over 600,000. So obviously the percentages across the state are going to be somewhat higher. And when you look at this map, I mean, it's pretty intuitive that the states in southeastern Pennsylvania and south central Pennsylvania that have both agricultural production as well as a lot of development pressures, that those are the counties that are going to have the higher percentages of land enrolled. But it's still interesting you see Berks County, that almost a third of the agricultural land is enrolled in the program. And as you get into western and northern Pennsylvania, the percentages are considerably lower. And again, a lot of this is intuitive, but it still is interesting just to look at the numbers. Okay, so I want to talk kind of generally about what are some of the questions, or what are some of the issues that are addressed by state programs. And so the first question, I think, is, well, who holds the easement? Who is going to be charged with enforcing that, or having some degree of oversight if it's not to make sure that the property owner is complying with the terms, is not engaging in any activities that are not permitted. Is that going to be a government entity? Is it at the state level? Is it at a local level? Is it going to be some non-government organization, some land trust or similar organization, or is it going to be a mix? And as we see in Pennsylvania, we have a variety of organizations that are involved with the program. How are these easements funded? Is it coming from the general government appropriations? Are the private contributions? How is we're looking at a state program. How is the federal government or local government involved? Are there particular funding sources, like through environmental funds or litigation settlement funds? Some states are using funds from these sources to fund their programs. Just funds that are kind of from general real estate transactions are sometimes used to fund the programs. And then you have a variety, kind of sundry other sources of sales tax, cigarette tax, license plate fees. So there's really a pretty wide variety of sources that fund these programs. The length of the easements, generally, they are perpetual. So when an easement is imposed on the property, it will be on the property forever. And that's really one of the major distinctions as you look at these programs and compare them with tax assessment or ag district programs generally, is that this is permanent. This is going to impact the land forever, not just for a 10 or 15 year period. Now, there are some states will provide for termination for a change in circumstances, but the default normally is that these easements are perpetual. Now, as far as how do we determine how much money the landowner is going to receive, it's a difference between what's the fair market value of that land without the easement. So what's the fair market value of that land for development purposes? And then what is the fair market value with the easement, which, essentially what's the value of that land for agricultural use only? You look at the difference, that's what's paid to the landowner. And this is data from a couple years ago that in Pennsylvania, the payment, the average was just over $3,000 for this program. Okay, another thing that the programs have to look at is how do you rank these programs or the properties, because these involve the payment of public money to property owners. Obviously, there's a limit to how much money is available. So there has to be some way of ranking the properties to determine who's going to be paid for the land. And the criteria are pretty intuitive. I mean, how viable is this land long term for agriculture? Because you have to look at the long term. This easement is perpetual. So we want to make sure that if we're committing that public resource, that this is land that should be in agriculture forever. So we look at the agricultural characteristics. We look at kind of some of the economic issues that bear on that. We look at the location. Sometimes looking at what's the proximity of other farmland, look at other benefits that are going to be realized from committing the public resources to this land. There's always a question of, can you build another house, or can you, is there other kind of, commercial, other development that maybe is or is not related to the agricultural operation that can be constructed on the land. So these state programs have to deal with, and they frequently do allow kind of a carve out of one or two building lots. And Pennsylvania has provisions for for that. What structures are you allowed to build on the property? And that, I think, becomes an issue as agriculture, maybe looks a little different today than it did 10 or 20 or 30 years ago in terms of what farmers are actually doing on the land. Okay, state programs, and Pennsylvania has this requirement as well, as that the landowners have to be in compliance with a conservation plan. So, if we're gonna commit to public resources, then the farms have to be kind of doing what they're supposed to be doing. Some states have kind of connect the purchase of ag conservation easement with some of their the other tools, the other programs, like preferential tax assessment, that maybe this is a precursor or prerequisite for that. Maybe you have to be included in an ag district, and Pennsylvania has that requirement. That Pennsylvania's ag district statute is the Agricultural Area Security Law, and to be eligible, for a farmer to be eligible, or a property owner to be eligible to participate in a purchase of ag conservation easement program, they have to be within an ag security area. So that is a precursor. And I apologize, I think the lighting on my screen seems to be getting brighter and darker, and I'm in a room that has no windows, so I'm not sure what is causing that. Okay, also there can be other benefits. Land that is enrolled in a purchase of ag conservation easement program the state program may provide for other benefits. Maybe protecting from local regulations, maybe from eminent domain. So, when we talk about all of these different legislative tools to protect farmland, oftentimes there is overlap between the protections that are granted through these different tools. Okay, so talk a little bit specifically about Pennsylvania, and again, we're really just scratching the surface of this. If you would like for us in a future program to really drill down more, please let us know. But to start with a discussion of these programs, the authority for the programs, the statutory and the regulatory authority, are in the Ag Area Security Law and then the Ag Conservation Easement Purchase Program, respectively. So the Ag Area Security Law is in Title III of the Pennsylvania statute, Section 901 to 915. The Ag Area Security Law is Pennsylvania's Ag District program. So the Ag Area Security Law is providing for how we are creating ag security areas, what are the benefits of being in an ag security area, and then a portion of this statute is devoted to the Ag Conservation Easement Program. At the regulatory level, in Title VII, Chapter 138E, that chapter is devoted specifically to this program. So, as you have questions, or if you want more information, that's really the starting point, is to go to the statute, go to the regulation, and then looking at county programs or some of the other information that the PA Department of Ag, Bureau of Farmland Preservation has. But those are the foundational legal documents that are going to provide a lot of the specific details. So the history of Pennsylvania's program was established in 1988. First easements were purchased in 1989. And, Pennsylvania really is the national leader. But if you remember back to an earlier slide, there were a number of states that started these programs in the 1970s. So Pennsylvania was certainly not the first, and really kind of trailed behind these states by about some of these early states by about a decade. But it has been a very, very popular, well-supported program at the state level and at the federal level. And if you remember back a few slides back, not every county in the state has a program. So there are 58. Obviously, Pennsylvania has 67 counties, so there are 58 county programs out of the 67 that receive state funding. So those counties that are in areas where there is less development pressure, perhaps less agricultural activity, there's not as much of maybe a need, or there's not going to be as big of a difference between the fair market value of the land for development and the market value of the land for agricultural use. Okay, so just to highlight a few specific provisions that are within, and the citations that I have here are from the statute, and so this section 914.1 is really the specific statutory section that really provides the authority for this. Just highlighting that these easements are perpetual. Also, there's been a lot of, in recent years, a lot of activity related to oil and gas. The statute specifically states that an easement does not prevent oil, gas development or underground coal removal. Similarly, it does not prevent utility rights of way. So that activity can still take place on the land. Now, as to the issue of, because there often are a lot of questions on subdividing the land or building additional residences. The language here on this slide comes from the statute, and there is authority for during the time of the easement. So after the easement has been imposed upon the land, there is authority to construct one residence on not more than 2 acres. So it does allow for maybe the next generation to have a house that's constructed. Now, generally speaking, when you look at subdividing the land, there's a prohibition on subdividing land if that subdivision is going to harm the economic viability of agricultural production. So obviously, this is a very general statement. That's what's provided in the statute. When you look at some of the county programs, the other kind of guidelines are going to provide a little bit more clarity on that. But the overall purpose is you can't harm the economic, or the subdivision can't harm the economic viability. So we're putting this easement on the property. We want to make sure that you're going to be able to have this agricultural production well into the future. Okay, so just talk about kind of as a wrap up, just to kind of compare these purchase of ag conservation easement programs to the other farmland preservation type programs, like in Pennsylvania, Clean and Green, or the Ag Area Security Law. The conservation easements, that one of the pros or the benefits of this program in comparison to the other is this is permanent. There is a permanent easement that is limiting non-agricultural development. Clean and Green doesn't do that. And in other states, tax assessment, preferential tax assessment programs don't do that. They provide an incentive. In Pennsylvania, we have rollback taxes that if you develop that land, and you have to pay the tax benefits back, but it doesn't prevent you from developing that land. These programs do. These programs prevent the development. So that is very much a benefit of these programs. But on the other side, they're expensive. I mean, we are taking public money. And you saw the figure in an earlier slide that on average about $3,000 per acre that the state or local or federal government is committing to, is paying that money. Now, the point of these programs is to prevent, to remove that disincentive to developing the property. Well, if you have a farmer who had no intention of developing their property, and we're paying them $3,000 an acre, you know, there's a bit of a windfall there that we're paying for to preserve land that was going to be preserved or had a low likelihood of being developed. And on, you know, kind of related, if you are in an area where there's a lot of development for agricultural land, you know, it may be that farmer is able to sell land to someone else, and maybe the value of that land doesn't decline as much as was expected. So, you know, these programs are permanent, you know, and that's a great benefit, but there is a financial cost to these programs, or a greater cost than there is for some of the other farmland preservation type programs. You know, one of the issues that I think always comes up as you talk about these programs is, you know, what is agriculture? What, you know, and specifically with the conservation easements that require there to be only agricultural activities on the land. Well, what does that mean? You know, as we start to, you know, as agritourism and other similar activities really become a much more prevalent part of a far greater number of agricultural operations, what does it mean? What does agriculture mean? How are we defining that term? How do we look at that, you know, as energy production becomes a more integral part of a lot of farms as well? How do we look at that term? So, you know, are we favoring or restricting certain types of agricultural operations? And as we look at the fact that these easements are perpetual, I think is one of the real strong points of these programs. But on the other hand, do we want to be tying up or restricting the land well into the future? Because, you know, circumstances do change. And, you know, as we are committing the resources today to preserve the land, is this the right land to preserve? And, you know, as we look at considering the applications, the criteria to consider the applications, you know, we should be looking at or making that decision that we're preserving the right farmland. But that certainly is you know, I think it's something that we have to consider to make sure that since we're doing this for the long haul, we really need to make sure that the land that's being preserved is kind of the right farmland. Okay, so with that, I think I will. We have about a few minutes for questions. I've not been following the Q&A tab, so Audrey, I will leave it to you to pull that tab up.
All right. Okay. We've got lots of stuff. I've been collecting them and kind of compiling them to put them together. So first of all, Mr. BJ Reefer Westmoreland says that it's important to mention that the federal program requires an applicant to apply through a local or state approved program. You can apply to the federal program. And I just wanted to mention that is also in our resource sheet. We have links to all of the available county information.
Yeah. And that, I mean, because the federal program, it works with partner organizations. It works through partner organizations. And that certainly is true. You know, as you look at these programs, this type of program, often there are multiple entities at multiple levels, private and NGOs that can be working together on these.
Right. Okay, we have a question that says, how does the qualified entity manage the easement? Does the farmer not manage the easement because he or she is still the owner? And so I think the qualified entity there is referring to the government.
Well, it would be the government, you know, if we're talking about the federal program, if we look at this more broadly, someone has to manage the easement to make sure that the restrictions are being complied with. And so the farmer isn't doing that because obviously the farmer has an interest. And if the farmer is in violation, then someone has to be in a position to say, okay, farmer / landowner, you can't do this activity. And so they have to be in a position to if necessary, to exercise legal authority to stop that action, because there have been some public benefits provided to create the easement. We have to have someone or some entity that is in a position to enforce that. So,
Okay.
when we talk about managing the easement here, we really are talking about making sure that the restrictions are complied with, making sure that there are not ineligible activities taking place on the land.
So this kind of leads into this other question. How does the government make sure the system does not incentivize a farmer who already has no intention to develop the ag land? In other words, a farmer might already have no intention to develop or replace the land, but might want to also receive a PACE program benefit.
Yeah, I mean, that's a real issue. I mean, does every landowner that enroll in this program, are they on the cusp of developing their property? No. By paying this money and having the easement on the property, we are locking it down, that we're saying, okay, you may not have an intention to develop it, but maybe your child will, or maybe someone who acquires the property at a later time will, or maybe you will at some point in the future. So, if you look at this, if you look at this as to what's the best use of public money, we should be looking at where are those properties where there is a greater incentive for a farmer to develop the land. And I think that's where, when you look at the map of Pennsylvania and you see the southeastern and south central PA having the higher participation in the program, that makes sense, because, those are the areas that, because of the value of the land, because of the development pressure, it's more likely that a farmer is going to develop that property, either now or 5 or 10 or 30 years down the road. But, as far as getting as specific as, does this particular farmer intend to develop the land, I don't know how we could ever really monitor that, other than looking at external factors and kind of making a generalized determination that this land is in a place where there are definitely where incentives exist for this land to be developed.
Great, thank you. We have a question about fair market value. So if a conservation easement is on land that is taken through eminent domain, what is the fair market value? Just the land itself, the crops being grown on it, or something else? So
if a conservation easement is taken through eminent domain, I mean, you would look at kind of that classic definition of what's the value of the property prior to the rights that have been taken, and what's the fair market value of the land after it has been taken. I think if there are crops growing on it, and let me just read this question: if the conservation easement is on land that's taken through eminent domain, then it would be the value of, whatever the difference in the fair market value is. Now, in Pennsylvania, for land to be eligible for this program, it has to be in an ag security area. And when land is in an ag security area in Pennsylvania, there are extra hurdles that an entity has to go through to acquire that land, to acquire rights through eminent domain. They have to, the entity that's seeking to acquire the land has to go through the Agricultural Lands Condemnation Approval Board, or ACEP-ALE, and they have to demonstrate that there's no reasonable alternative to taking that land. So I know that doesn't directly answer that question, but in Pennsylvania, there's a disincentive for entities to acquire preserved land through eminent domain.
Right. We've got a couple questions on, so to what extent does preserve mean preserve? So can cell towers be built on the ease land, or solar farms be constructed?
Yeah, I mean, it's a good question, and I think you really have to look at look at some of the regulations to get kind of specifically what is permitted what is not. And I know, over time, things change, additional issues kind of rise. And, I think that's a good question that I would just direct you to the specific statutes, the regulations, and some of the county guidelines to see specifically what can be constructed and what can't.
Which that kind of leads into this question. Are there any court cases you know of to remove land from, I guess, the conservation easement? It's not really a program.
I'm not aware of anything in Pennsylvania that has addressed that. And, there was, so I guess that simply answers the question of that I'm not aware of anything that would seek to, based on a change in circumstances, remove that easement. I mean, I think that raises a number of questions, but I'm not aware of any case law in Pennsylvania.
Right. And then we've got a couple more here. We'll just keep going. If anyone needs to log off, that's fine. But let's see, what would happen? Okay, so there's kind of two questions that sort of go together. So
and if I can just clarify, prior to 2011, there was language that said that after 25 years, if the land was no longer viable for agriculture, that the easement could be removed. But I believe that language was removed in 2011. So there is not a legal authority for the removal of that easement.
Right. Okay. So this is dealing kind of with entities. So if we put our farm in a revocable trust, is it still eligible for a conservation easement? And then there's another question that asks, what would happen if a nonprofit easement owner agreed with a fee owner to merge the easement with the fee estate or eliminate the easement? Would such an agreement be void? So the first is, can you? Yeah,
I think that the ownership structure doesn't matter.
Okay.
So, I mean, I think there's still the property owner, regardless of who it is, could apply.
And then another question, I answered this, I think I did correctly. Payments are just, it's just a one-time payment, correct?
Generally, I mean, you'd have to look at the provisions of the specific program, but frequently it is just a one-time payment.
Okay. And then we've got this, I don't know if you know this, but this asks how many of the 606,000 plus acres in Pennsylvania that is subject to conservation easements are forest land? Are there any important legal or practical issues for forestry activities that arise under these types of programs?
I am not aware of that, of how much of that land is forest land. So that's a good question. I do not know. I guess you get to some of the question of what gets to that question of what is agriculture, what are agricultural activities. But I would suspect that, typical forestry management would, that there really wouldn't be any impacts on that.
Right. We got two more questions here, and then this one we'll email this person. This asks, is there a publicly available database of conservation easements? How would a local resident know whether a particular property is protected by conservation easements? Does the resident need to go to the county courthouse or the office of recorder of deeds to answer that question? I'll say that I put together this resource page, and on all of the county websites that I've listed, many of them include data about the land that is in their program, but it's not comprehensive. Ross, do you have anything to add to that?
This is going to be recorded. So if you go to the courthouse, you're going to be able to see the easement. So if you want to know a particular property, you can go to the courthouse. And then, as Audrey said, I would look to either the county or the state, for other questions.
Yeah, some of those county websites are very comprehensive and have extensive information. Some of them have not very much information at all. So really depends there. And then there's a question that says, what about Hempt Farm in Cumberland County recently? Did they succeed in taking and or condemn the land for development? I'm not familiar.
I am not sure. I think I know the property you're talking about. I'm not seeing that question here, but I am not sure what the result of that proceeding was.
Okay. And then we've got an anonymous attendee who's asking kind of a very specific question about inviting me to someone's being asked to be buy land, asking $20,000 an acre. Can you offer thoughts on this? Well, I'll just read it. I've been approached by a retiring farmer whose land is in preservation, inviting me, an active farmer, to buy his land. However, he's asking $20,000 per acre because that's what other wealthy buyers in the area are offering, although they themselves are not farmers, but simply just want to own property. Can you offer me thoughts on this?
Well, I think that raises the issue of sometimes when the development rights are taken out, and then the property is sold in the future. I mean, anecdotally, I think there are instances where the value of the property has not declined. And, certainly if that's happening on a widespread basis, that, can raise some questions about the program. But at an individual level, I mean, that farmer or that landowner is free to sell the property for as much as the farmer is able to sell the property for. It is restricted. And so in theory, those restrictions should decrease the value of the property, but it may not do so in every case.
Okay. I think that wraps up all the questions that we have. I think we've gotten through them all. Oh, so we answered that live. The CLE form is posted in the chat. If you missed it, please email me. My email, Audry Thompson, is on the website, AET17. I'll get it to you. And Ross, do you have anything to add?
No, thank you very much.
All right. Thanks all.